Next bill on the agenda is House File 1522. Chair Nelson moves that HF 1522 be re-referred to the General Register. There is an author's amendment. Rep. Nelson moves that A23-0087 amendment. Representative Nelson, would you like to give any brief comments to the amendment?
And Madam Chair and members, the 0087 amendment is basically going to be our omnibus policy bill coming out of committee this year. These are bills that we've heard during session. It's a combination of all of those, and that's what this bill is. Like I said, it's there's a list of those. I think in the I don't have it here in front of me. It wasn't in my packet here. I can read it that way. I can read it. Section 1 of the bill is access by labor organization of personal data, so that they can do their organizing that they need to do, that they're allowed to do. Number 2 has to do about employee salaries and benefits during shutdowns. In the event of a government shutdown, the employees will get paid. We always do that afterwards. This way, they know ahead of time they're going to get paid for the time that the government shut down. Section 3 is planning for e-learning days. Require the school boards that meet and negotiate with their exclusive representatives, teachers before adopting an e-learning day. Now, Section 4 is limitations on licenses, the Tier 1 licenses. And under the bargaining unit with Pelra, under Pelra. Section 5 allows community education, early childhood family education teachers to obtain tenure or a continuing contract. Section 6 has to do with probationary periods, employment and teaching contracts. Section 7 is probationary periods, the discharge and demotion of teachers. Section 8 is compliance orders. Section 9 has to do with prevailing wage on projects and defines those projects. Section 10 is public employees or employees definitions. Section 11 has to do with teacher's definition. Section 12, terms and condition of employment. Section 13, payroll deductions and authorization to have their dues withheld by the employer. Section 14 has to do with liabilities, rights, and obligations of employees. Section 15 deals with inherent managerial policy. Section 16 have to do with time off. Section 17 is bargaining with information and rights and obligations of employers. Section 18 is access and that is rights and obligations of the employees, or employers also. Section 19 is majority verification procedures. If there is a vote. Section 20 has to do with authorization signatures. 21 has to deal with unfair labor practices in law. 22 is employee-sponsored meetings and communications, prohibiting firing or disciplining employees that declines to attend or participate in an employer-sponsored meeting. Sometimes those are called captive audience meetings. There's remedies that do with that, notice that have to do with that. Section 23, restrictive franchise agreements, prohibits franchisees prohibits franchisors, cannot restrain, or prohibit a franchisee from soliciting or hiring employees from one Jimmy John's, as an example, to another Jimmy John's. If a person wants to change jobs or get the job closer to home. Section 3 has to get, again, franchise agreement amendments. Section 4 has a severability clause that it's always in the bills that provides if one part of the bill is declared unconstitutional, it doesn't bring the whole law down. Section 24 is authority to inspect for OSHA. Again, this was part of the OSHA bill. 24, 25, 26, 27, and 28 have to do with the OSHA bill we heard earlier. Section 29. Maybe I can get the staff to help me with this, and I'm running out of voice here.
we'll call upon Marta James to give further explanation.
Thank you, Madam Chair and members. So I'll start with section 29. So sections 29, 34, 35, 38, 39, 40, and 41 all are making housekeeping and technical changes to the construction codes and licensing statutes. And those are from House File 2213, which is a Chair Nelson bill. Sections 36 and 37 from House File 1551, those exempt load control equipment from inspection requirements as long as certain installation requirements are met. Section 42 from House File 1872, that is the requirements for placing permanent micro-unit dwellings surrounding a religious institution that I believe was heard earlier this week or last week. And then sections 43 and 44 are also part of the changes to PELRA that come from House File 1691.
Thank you, Ms. James. Chair Nelson?
In section 30, which wasn't mentioned, that has to do with the bill we heard about refrigerants for, new refrigerants for air conditioning that are coming online. And so that's the bill. And again, this is the bill that we have for will be House File 1522 will be our policy bill of the Labor Committee.
Madam Chair. Madam Chair,
Yes, Representative Schultz.
I don't believe we've adopted this amendment yet.
Well, that's what I was getting to.
Very good.
All
So I
right.
just wanted to make sure that, for the record, that I request a roll call for the adoption of the amendment.
Excellent. Chair Nelson, have you finished explaining your amendment?
Explain the bill, yes.
Okay, those in favor of adopting the okay.
Roll calls.
Oh, we will have a roll call on the 823 amendment to get the bill in the shape the author would like. So please start the roll call.
Chair Nelson?
Aye.
Nelson, aye. Vice Chair Berg?
Aye.
Berg, aye. Lead McDonald?
Aye.
McDonald, aye. Representative Daniels?
Aye.
Daniels, aye. Representative Greenman?
Yes. Aye.
Greenman, aye. Representative Hill?
Aye.
Hill, aye. Representative Hussein?
Aye.
Hussein, aye. Representative Jordan?
Aye.
Jordan, aye. Representative Kozlowski?
Aye.
Kozlowski, aye. Representative Meckland?
Aye.
Meckland, aye. Representative Myers?
Aye.
Myers, aye. Representative Schultz?
Aye.
Schultz, aye. Representative Wolgamott is excused. Madam Chair, with the conclusion of roll call, there are 12 ayes and 0 nays.
Okay, Chair Nelson, to your bill.
We have another.
Amendment
Madam Chair and
adopted.
members, as we walk through the bill and explain the amendment, that's the bill. Again, this will be our policy bill from the Department, from the Labor and Industry Committee for this year.
Okay, there is an A3 amendment from a representative, Lead McDonald. Would you like to move and explain your amendment?
I'd like to move the A3 amendment. Thank you, Madam Chair.
Would you like to explain it?
Oh, yes, Madam Chair. Thank you. Well, Chair Nelson, for the most part, I think you put together, drafted a pretty good labor bill that many of us on this side could get behind. There are some provisions in the bill that we have some heartache on, but overall, I think you've done a pretty decent job in creating an omnibus bill. Certainly is small enough and definitely less than the HHS bills that I was accustomed to in the past. So for that, we thank you. One particular provision, though, Bill 1690, and that's what my amendment does, is actually takes that out. No offense, Representative Jordan, but hearing from the industry and those who are involved, including our school districts and many others, we just feel that that is an overreach of government. It provides specific and huge modifications to current state labor laws. It also affects state education code as well as the Minnesota Government Data Practicing Act. And it disrupts collective bargaining and other employment for teachers. And we just think it's pretty far-reaching and disrupts current state law now in collective bargaining. And we just, we are very concerned about that provision, especially providing information for teachers that they are forced to provide information regardless, without a say. That particular provision we talked about before is really something that we don't think is very fair and should not be a part of your bill, Mr. Chair. So for that, that's my amendment, and I'll open up for some questions and discussion, Madam Chair.
Chair Nelson, would you like to defer to Representative Jordan on this?
Well, Representative, Chair Berg, I'll just state that I don't support the amendments, and if Representative Jordan wants to talk about it, that's up to you as the chair.
Thank you, Mr. Chair. Representative Jordan.
Thank you, Madam Chair. And Representative Mecklin, don't worry about offending me. You should worry about offending public employees who are workers in this state. The people that I would be worried about offending are teachers, are custodial workers, firefighters, parole officers, park rangers. Madam Chair, you could cut me off because I could keep going for hours and hours and take the entire committee time talking about all the employees that this will give a voice on the job to. And in fact, by just deleting all of these public employees, we are just telling these workers that they don't deserve a voice on the job, and that's wrong. Pell was written to give these workers a voice on the job, and it has not been touched since then. And since we haven't touched Pell, we've continually eroded the ability of these employees, these librarians, these bus drivers, the people who answer 311, and the people who fill our potholes, who plow our streets, who work for a state agency, who are media specialists, who are paraprofessionals, who are nutritional workers. Those are the people that deserve a voice on the job, and they haven't had it. And we need to give it to them by updating Pell. So I think this amendment is pretty, I think it says a lot about the kind of workers that we care about and we need to uplift. And so let's make sure that we're uplifting all workers with our labor policy bill, Madam Chair.
Thank you, Representative Jordan. Any follow-up remarks, Chair?
She said better than I could.
Madam Chair?
Yes, Lead McDonald.
Yeah, just to follow up.
Sure.
Yes, actually, it was Representative Jordan said Mecklin, but that's fine. He can take the stuff instead of me. But, yeah, that's all right. We do that. You make some very good points, Representative Jordan, but under current law already, those valued people who keep our schools ticking, in addition to the school teachers and principals, they already have a voice at the table. So to say that they don't is completely incorrect. It's not fact. In law, the librarians, the cooks, the maintenance, everyone that keeps the building running and keeps school running, already through collective bargaining and the union organizations have a say at the table. To say they do not is completely wrong. Chairman, you know the facts. So my bill, my amendment takes her language out because it's so far-reaching. Not to mention it forces individuals to publicly give their information to union organizations, whether they want it or not. I don't think anybody should be forced to give their information, except to the IRS and maybe the Department of Revenue, should be forced to give their information away if they don't want to. So, Representative Jordan, those people who we care about, we all care about, anybody who'd be stupid to say they don't care about, those who make and work hard in the schools, they have a voice already. They have collective bargaining, they have union organizing, and they have a voice at the table, thank goodness, to many years of work by legislators down here, long before all of us got here. Yours is too far-reaching, to be honest, and it forces one hand to the other. So therefore, I would ask you, Chairman, to support the amendment. And with that, I ask for a roll call.
Thank you, Lead McDonald. Any quick follow-up, Rep. Jordan?
Madam Chair?
I see you. I'm going to give Rep. Jordan an opportunity to respond if she'd like.
Madam Chair, I love public employees, and I love that this bill takes care of them. Please vote no on the McDonald amendment. And I will say it could be worse. I accidentally called Representative Heinzman Representative Hansen yesterday. So
You were close with the...
throwing them all around. So those H's and M's throw me off.
Thank you. Mr. Chair.
Madam Chair, Representative McDonald, when you talk about giving information, the unions, the collective bargaining, or the unions or the representatives or the exclusive representative for these employees, they need that information. They are required by law to represent these employees, whether they're in the union or not in the union. Without the information that they're being given of who these people are, they don't know who these people are and who they have to represent. They're required by law to represent them, whether they're paying dues or not. So that's why they need the information. Again, I say vote no on the amendment.
Thank you, Mr. Chair. A roll call has been requested.
Madam Chair.
Representative Schultz, quickly.
Thank you, Chair Berg. To Representative Jordan, I just wanted to ask, there is a great expanse of the data that's allowed to be transferred here. Did your bill go through the appropriate committee to kind of see that particular piece of the bill?
Representative Jordan.
Thank you, Madam Chair. The bill in this language was heard in the Labor Committee, it was heard in the Education Policy Committee, it was heard in the State Government Committee, and it was heard in the Judiciary Committee. And so it's important to remember that this language, I had two versions of this bill. I had the language that was heard here, I had the Comb bill. All of the relevant committees heard the pieces of the bill that were relevant to that committee jurisdiction. So this language has been heard in the Judiciary and Civil Law and like 12 other things in that committee's titled jurisdiction, but it was examined by Chair Becker-Finn's committee.
Follow up?
Yeah, thank you, Madam Chair and Representative Jordan. That is helpful to know. Is it House File 1691? Is that the clone bill to this? So we didn't hear that in this that particular bill in this committee. I do appreciate that we at least heard the language, and so thank you for that information.
Thank you, Representative Schultz. If the clerk would take the roll. On the A3 amendment.
Chair Nelson?
No.
Nelson, nay. Vice Chair Berg?
No.
Berg, nay. Lead McDonald?
Yes.
McDonald, aye. Representative Daniels?
Aye.
Daniels, aye. Representative Greenman?
No.
Greenman, nay. Representative Hill?
No.
Hill, nay. Representative Hussein?
No.
Hussein, nay. Representative Jordan?
Jordan, no.
Jordan, nay. Representative Kozlowski?
Kozlowski, no.
Kozlowski, nay. Representative Meckland?
Yes.
Meckland, aye. Representative Myers?
Aye.
Myers, aye. Representative Schultz?
Aye.
Schultz, aye. Representative Wolgamott is excused. Madam Chair, with the conclusion of roll call, there are 5 ayes and 7 nays.
Thank you. With 5 ayes and 7 nays, the amendment is not adopted. Further discussion to the bill.
Thank you, Madam Chair.
Representative Nelson.
Thank you, Madam Chair. And again, this is just an update of some of our statutes. It's cleanup language for Dolly. And it's, like I said, we've heard all these bills and had long discussions on them in committee. So I ask for a green vote.
Thank you, Mr. Chair. Representative Schultz.
Thank you, Madam Chair and Representative Nelson. I just wanted to kind of draw a little bit of attention to a portion of the bill that I don't believe that we heard. I don't even know that it has a House file in this particular legislative session. I believe it is found in Section 9 of the bill. And so Chair Nelson, I have a great deal of respect for you, and to have learned from you during this session has been a true joy. You're an elder statesman in this body, and I wanted to find out from you why we didn't hear these provisions as it relates to prevailing wage, and why we're finding them here in this bill now. So for those of you paying attention on the adopted delete all amendment, we are on page 6 and line 6.24.
Representative Nelson.
Madam Chair and members, this is language that came to us, and we didn't hear it here, but you're right, that is new in this bill. Page, I'm just trying to find the right page. What page did you say?
Yeah, we're on, thank you, Mr. Chair, Representative Nelson. We are on 6.24 under the
And this came to us from the capital, or the bonding committee. He's a way to say it, capital improvements, I guess is what it actually is. This is currently practice that is done by that, but this is that projects that are paid for with state dollars would have to require through whether acquisition of property, pre-design and demolition, that the money goes to those issues that these public facilities have to pay prevailing wage.
Representative Schultz.
Yeah, thank you, Chair Berg and Representative Nelson. I just wanted to call attention to that, just so we're following our process here as it relates to our omnibus bill. I think there's probably plenty of stakeholders that would have loved to have input on that, and frankly, I wonder if if we're going to be taking public input on this, if there's a plan for that at this time.
Chair Nelson, follow up.
Madam Chair, if there's somebody here that wants to speak on that position, we can take input But like I said, the rest of the bill, we've heard plenty of testimony on that. We've heard plenty of testimony in the past about prevailing wage on both sides.
Thank you, Mr. Chair. I would just note that this amendment has been posted for more than 24 hours. We do have a testifier. Please state your name for the record and begin your testimony.
Good afternoon, Madam Chair, members of the committee. My name is John Pollard. I'm the Legislative Director for the International Union of Operating Engineers, Local 49. We represent about 14,500 men and women who operate heavy machinery on construction, energy, mining, and other projects around the state. Representative Schultz, to your question, I can't describe where it came from, but I can describe what it does a little bit and why we have an interest in it. I only speak on behalf of the operating engineers, not the other construction trades. This particular language is intended to make sure that projects that are funded by state dollars contain the prevailing language that is already in state law. So the way we would view it at Local 49 is that it is a clarification of existing law. Existing law already applies prevailing wage to projects, capital projects around the state that are funded through general obligation bonds. This language makes sure that it also applies to other capital improvement projects, say projects that might be covered by direct appropriation. Happy to answer any questions.
Thank you, Mr. Pollard. Follow-up, Representative Schultz?
Yeah, thank you, Chair Berg. I think as we're looking at this, and it's important for us to shine a light to this. In fact, if given the opportunity, maybe I would have signed on to this bill, Representative Nelson. So I just, I wanted to call attention to that, and just there might even be others in attendance who maybe wanted to provide any comment to this. But we just want to work together to find the way forward on these pieces of legislation. I think that as a part of that, it strikes public right before building, and so whether it's Representative Nelson or your testifier in this case, can you kind of lay out for us what the implications of that would be from those provisions that were struck out of law?
Mr. Pollard.
Madam Chair, members of the committee, Representative Schultz, I'm certainly not a prevailing wage legal expert. However, my understanding is that applies to projects that may not be publicly owned eventually, that projects that are being built by public dollars that eventually may become into private ownership.
Thank you, Mr. Pollard. We do have the commissioner here if she'd like to say a few words on that. Please state your name for the record and proceed with your testimony.
Thank you, Madam Chair, members of the committee. My name is Nicole Blissenbach. I'm the Commissioner of the Department of Labor and Industry. My understanding of this specific change to law is to capture the situations where we have public money going towards aspects of a project, but maybe not all of it, to ensure that we still have the prevailing wage requirement. So if public money is going to the design, I think the specific words that were added, design, pre-design, that prevailing wage requirement would then attach to that construction project to ensure that we are getting the benefit of what the prevailing wage laws do in fact give, good workmanship and the cost savings that we see from projects being done on time and under budget.
Thank you, Commissioner. Any real quick follow-up, Representative Schultz?
Oh, absolutely. Thank you, Madam Chair. And so can we? This is really important that we're getting this information right here, and to understand the scope of how this kind of changes our law. To the Commissioner, am I understanding correctly that the department supports this language change, or would you see any need to tweak that?
Commissioner.
So we did, in fact, talk with stakeholders about a slight change to the language that we believe is necessary to just ensure that when we're talking about the money being used for pre-design and design work, even though it will trigger prevailing wage obligations on the project, to make sure that it doesn't attach a prevailing wage obligation to the pre-design and design work, because we don't actually have classifications for architects or so on and so forth. That came a little late, so we weren't able to get the 24-hour rule here, but we did, in fact, amend that language slightly in the Senate to ensure that.
Thank you, Commissioner. Follow-up?
Yeah, thank you, Madam Chair. Should we be seeking to amend this bill further to meet the where the Senate's at this point, or Representative Nelson, would you see the path forward for this bill having a different opportunity to get that language right?
Chair Nelson.
This is going to the, Madam Chair and Representative Schultz, this is going to the general register. We could amend that on the floor, or we could accept the language. Once we pass it, when it comes back from the Senate, we could do that in a conference committee, or accept the language if it comes back from the Senate with it on. So there's many opportunities to fix that.
Thank you for your concise answer, Mr. Chair. Any real quick follow-up again?
Thank you, Madam Chair. I just say that I think that for us, there are so many bills that we heard this session that earned bipartisan support, and I'm just disappointed that today we have to, the decision was made that we're not going to be removing 1690 and 91 from the bill, and so at this time I'd request a roll call.
A roll call having been requested, I will ask the committee assistant to call the roll. Just kidding. I'm sorry, Lead McDonald.
Yes, thank you, Madam Chair. I just have one last question and comment for Representative Nelson. And I voiced this when the bill came in regarding subsection 4 regarding the occupational safety and health citation. So the concern that many have, including myself, is that fact that a citation will be made public with all the information, and it very well could be dismissed later. I think it's very harmful to contractors and anyone that is an employer that could be wrongfully or mistakenly given a citation. Once it's made public, it's out for discussion and debate, and a reputation could be soiled because of that provision. Right now, current law also makes MIN-OSHA citation records timely and readily available to the public website without going public first, without an opportunity for any employer to defend himself. So I'm curious, as a contractor yourself and a builder, don't you have the same concerns that should a citation be made public, and then later, weeks later, or maybe a month later, that it was dismissed, a reputation could be disrupted or soiled or ruined?
Chair Nelson.
Thank you, Madam Chair and Representative McDonald. As we discussed when the bill was in front of us about the citations, and there was concern about OSHA coming out and on sites, and unless there's a citation issue, there's going to be nothing to made public. Part of this is worker safety. If I'm working for a contractor and he's been cited for doing something unsafe and I don't know about it, I could continue as be working for that contractor doing that unsafe practice and end up getting injured. This is a way to protect our workers, to make sure that they have the information to know that XYZ contractor I'm working for may be doing something that skirts the law or is unsafe, and then I can have the decision whether I want to continue working for that contractor or not. That's what this is about. Currently, union contractors, this information is given right away to the unions, and the unions then share it with their membership. So on the union sites, this is happening right away, so the workers know whether they're working in a safe work site or not. For the non-union, it does not. This gives 20 days for them to start the process or to have the process of debating whether or getting the citation thrown out. But again, this is to protect workers in the workplace.
Thank you, Mr. Chair. Real quick follow-up.
Are we under a timetable, or don't we go
Little bit.
to 30?
We have another.
Real quick, Representative Nelson, yes, that you make some very good points, and it certainly is about public safety. But the perception could be that the employee made a mistake, and he or she was the fault for the accident and for the unsafe environment, not the employer. But because the citation is made right away, made public, without investigation, without due process, you're really hurting and harmful the contractor and the employer. So under your scenario, it just doesn't give due process to the employer. It's not always a safety hazard on the job site is not always the employer's fault. It certainly could be, and that's why we like the protections that some of your bill provides. But it doesn't do anything to help the employer should an employee practice unsafe work procedures. And then it's made public. Oh, A, B, C contractor, unsafe to work for, someone got hurt. I just think that, I hope that maybe when it comes to the House floor, you'll reconsider that, or in the meantime, consider that protection. I think there could be a win-win for the employee and the employer regarding your citation and made it public so quickly.
Thank you, Lead McDonald. I'm going to move on to Representative Meckland, whom I missed.
Thank you, Madam Chair. This might be a question for the commissioner. In other committees, we've heard a lot about allocating money from like the RDA for weatherization and being, and or other funds, and being that those would be private property getting improvements with what we're now calling public funds. Would those be subject to this very rule here?
Commissioner?
Yes, thank you, Madam Chair, Representative. So there are a number of prevailing wage obligations in law. There's the Prevailing Wage Act under 177 that we talked about earlier. There's also some prevailing wage obligations under 116J, which primarily attaches to grants and loans from DEED or Minnesota Housing Finance. So many of those projects that you're discussing already are subject to prevailing wage obligations, even though they're not owned by a public entity as you would typically think of under 177. So I hope I'm answering your question, but yes, oftentimes those projects, if they're receiving grants or loans from DEED or Housing Finance, are already covered by prevailing wage obligations if they meet the dollar thresholds.
Representative Meckland.
Thank you, Madam Chair. So to that, if there was multiple parts of this aspects of this job going on, but for example, only 2 portions of it were being, they were given money from the state to accomplish those tasks. Let's just say it's roofing and windows, for example. Would everything else be subject to this then, or just those particular tasks that are being funded by the state?
Commissioner?
Madam Chair, Representative, it really is going to depend on what prevailing wage obligation it falls under. So in that certain circumstance, the money there would be specific to the construction of windows, roofing. So under 116J, it would be the project that is covered by the agreement for the grant or loan.
Okay.
Thank you, Commissioner. Follow-up?
Yep. Thank you, Madam Chair. This question is for Chair Nelson. I have a lot of friends that work in the unions and many that don't. Something that I've been struggling with all year is the union. We've heard that the unions are safer, they pay better, they have better benefits, they're better trained. Then why do you have to mandate it?
Chair Nelson.
Thank you, Madam Chair and Representative Meckland. The prevailing wage originally was designed, and it is still designed, as a way to protect local workers. It protects our workforce that we're giving money from the state, from the cities, from whatever, but it protects our local workers to make sure that the money we pay for taxes to go to a project, we have the opportunity to get that money back if I work on that project, as opposed to sending somebody up, contracting out from somebody from Texas or Louisiana or Mississippi and come up here and take the money from us and bring it back there. Part of the reason why we do public works and we do public projects is, again, to stimulate our economy in the state and in our local municipalities. When we do prevailing wage, that means that they come up here, they're going to have to pay our prevailing wage. They don't have to be union to do that. They actually don't have to be from the state of Minnesota to do that, but it's, again, they're going to pay our wages here so that our contractors have a fair shot at bidding on those jobs. That's what prevailing wage does, and that's the purpose of prevailing wage.
Thank you, Chair Nelson. Any other thoughts?
One quick further question, Madam Chair. Another question I have, and I've talked to some of my friends. So if you can give me an example, just a hypothetical number, like let's just pick $30 an hour as the particular pay for this particular occupation, right? Because it's such a competitive market, is there an opportunity for that union job employer to say they're going to give you $45 an hour because there's a very competitive market, or are you stuck at that? I honestly don't know.
Chair Nelson.
This is kind of getting beyond our bill, but Madam Chair and Representative Meckland, they can pay above scale. They can pay above the prevailing wage. But this sets a floor that for the projects that we're funding with our state dollars, that this is the bottom we're going to pay, again, so that we can make sure those jobs go to local contractors and hiring local workers.
Thank you, Chair Nelson. I think we're going to move on. Oh,
Yeah, one last question,
Lead
Madam Chair.
McDonald.
This has to do with your provision, actually. Mr. Chair, now, believe it or not, we don't come up with all the questions, right? We have outside friends and experts that want us to know some answers. So I particularly have a very concerned question that I wanted to ask when Representative Kayla Berg presented her bill, but didn't get the chance, regarding your section of employer-sponsored meetings, communications. I understand the bill, and I can support some of it, but because the language is vague, one could interpret that a religious organization or school would not be, would require them not to have all their employees attend a meeting on certain religious issues, pro-life issues, et cetera, et cetera. So under the bill as written, it's a very potential that a school, a parochial school, could not have all of its, or force, or require all of its employees to attend a meeting. And that is the question that my friend wanted me to ask, that this bill could potentially do that, that in a parochial school would be forced not to attend religious meetings. I hope I articulated that correctly.
Thank you, Lead McDonald. I'll allow Chair Nelson to answer, and then as the lead, I'll give you final remarks. Chair Nelson.
Chair Berg and Representative McDonald, what we're getting into is in the First Amendment, religious freedom rights. And what I take from your questions, you're assuming that everybody that works on that parochial school are all part of that religion. But say you work for a parochial school and you're Jewish or you're Muslim, and that's a Christian parochial school, and you require them to have to sit through that, would be a violation of that individual's First Amendment religious rights. We all have our First Amendment rights, but it's often said my constitutional rights end at the tip of your nose. And so I can espouse what I want to espouse, but I can't force you to espouse or to believe what I believe. And that's, we all have that individual right.
Final words, Lead McDonald.
Well, Madam Chair, Representative Nelson, you're a hard act to follow. But seriously, it's, as it is written, it could seriously hurt parochial schools and churches to at least require all of its members, all of its religious instructors to attend a meeting to talk about God, perhaps. And therefore, there's grave concerns outside this building as well. And perhaps you'll maybe think about that before it comes to the House floor with an amendment, because we certainly will.
Thank you, Lead McDonald. Any final words on the bill?
Good bill, vote yes.
Fair enough. A roll call has been requested. The CA will take the roll.
Ellie.
Just kidding.
I'll renew my motion that House File 1522 as amended be referred to the General Register.
Thank you, Chair Nelson. Take the roll.
Chair Nelson?
Aye.
Nelson, aye. Vice Chair Berg?
Aye.
Berg, aye. Lead McDonald?
Nay.
McDonald, nay. Representative Daniels?
Nay.
Daniels, nay. Representative Greenman?
Aye.
Greenman, aye. Representative Hill?
Aye.
Hill, aye. Representative Hussein?
Aye.
Hussein, aye. Representative Jordan?
Jordan, aye.
Jordan, aye. Representative Koslowski is excused. Representative Meckland?
Nay.
Meckland, nay. Representative Myers?
Nay.
Myers, nay. Representative Schultz?
Nay.
Schultz, nay. Representative Wolgamott is excused. Madam Chair, with the conclusion of roll call, there are 6 ayes and 5 nays.
Thank you. With 6 ayes and 5 nays, the bill passes.